Gibson, Dunn versus Koukis. There we go. Thank you.
May it please the court, Seth Prikoski for Gibson Dunn. May I please reserve 4 minutes for rebuttal? Yes. The appellate division erred because there are, at minimum, factual disputes regarding whether Koukis waived jurisdictional defenses asserted in his motion through his counsel of record, Gil Santamarina, an attorney admitted to practice in the state of New York, and an officer of the court who has never once corroborated Koukis' claims. Even assuming Koukis is not equitably estopped from challenging Santamarina's authority, and he is, Koukis failed to meet his burden of demonstrating unauthorized appearance of counsel as a matter of law.
Well, what specifically did Koukis actually do to lead you to believe that Santamarina was authorized to represent him?
Well, the answer to that question, Your Honor, is I have to start by the answer to that question, which is that we don't actually know exactly what transpired because Gibson Dunn has never received any discovery whatsoever on the intricacies of the attorney-client relationship between Mr. Koukis and Santamarina. However, based on the moving papers and the existing record that we have to date on the motion, there is at the very least sufficient evidence to conclude that Mr. Koukis authorized his co-defendant Joseph to retain Santamarina to represent him on behalf in this litigation.
What evidence specifically are you referring to?
Well, Your Honor, this email is in the email. This is in the email correspondence.
This is the email where Joseph said, "We've had a lot of conversations about this, and you knew about our corporate lawyer." Is that the one you're?
Well, that's right.
referring to?
There's a series of emails at record 167, 171, 183 to 186, in which they talk about they've had repeated conversations for years over what's being done in the
Do
litigation.
they talk about that, or does Joseph talk about that?
Well, Joseph talks about that with Mr. Koukis and with another defendant.
And does Mr. Koukis engage with that conversation?
Your Honor, he certainly doesn't deny what Joseph says.
It's met with a sort of stony silence. Like, what's going on here? Did he get the email? Did he read this part?
That's
There's
correct.
nothing there.
But Your Honor, in addition to the email correspondence, we have other things in the record here. We have the retainer agreement, which Joseph signed unambiguously on behalf of all of the defendants. That's also consistent with, as I said, repeated court filings for a period of nearly 2 years by an officer of the court on behalf of Mr. Koukis, who has never once stated that he lacked authority to represent Koukis. Even after the judgment, Mr. Santamarina filed a notice of appeal on behalf of Mr. Koukis and represented him by filing that notice of appeal. There is simply nothing other than Mr. Koukis' say-so 2 years after the fact.
Supreme Court had given you discovery, jurisdictional discovery, but that never occurred. Is that right?
Your Honor, we never received any jurisdictional discovery.
No, but had Supreme Court scheduled a hearing and authorized you to get discovery in advance of the hearing, and that just never took place, or I'm mistaken?
No, Your Honor. Supreme Court granted discovery, not discovery, it granted a traverse hearing on the issue of personal jurisdiction, not on the issue of Santamarina's appearance. In this particular action, Supreme Court concluded that, as a matter of law, Santamarina lacked authority to represent Koukis, that there wasn't even sufficient evidence in the moving papers to justify a hearing and discovery just to determine the facts of what occurred.
And this was a motion to vacate.
That's correct, Your Honor. This was a motion to vacate supported by a conclusory affidavit that Mr. Koukis put in. He essentially recounts the public filings that have happened in this case, and then he issues a number of statements. He says, I did not authorize Mr. Santamarina to represent me. I did not authorize Namalini to act on my behalf. I did not authorize Joseph to act on my behalf, but provides virtually no factual content, no factual detail about what did occur, when in fact he knew it, and what happened, which is simply why all we're asking for is a hearing to determine what in fact took place.
Can you tell me what the standard of review is regarding the court's decision about whether or not to grant jurisdictional discovery?
Well, Your Honor, as this court has but stated on several occasions, if there are factual disputes on a material question that goes to agency, those factual disputes need to be resolved at an evidentiary hearing when the court can actually find the facts and determine whether or not the movement has met their burden of demonstrating unauthorized appearance of counsel or not. On a simple motion, the movement, of course, bears the burden of demonstrating an entitlement to relief on the motion. And what we would submit is that a simple affidavit that just issues a one-sentence conclusory denial of authority is not sufficient to meet his burden. But at the very least, it's not sufficient to ascribe zero weight to the repeated statements of both his counsel of record and his co-defendant that Koukis did in fact authorize his attorney to represent him in this action. And what I would note is, even if it were the case that there were a misunderstanding as to whether or not Santa Marina had authority to appear in the action, file a stipulation noting that he was waiving jurisdictional defenses, file an answer, also waiving jurisdictional defenses, litigate the case for 2 years, there is also sufficient evidence in the record to conclude that Koukis was aware that this litigation was being done on his behalf, at least by 2018, which is when Santa Marina appeared.
And does he have to protest it in order to solidify his claim of lack of authority?
Well, Your Honor, the court would, at a hearing, would have to determine what in fact he did and did not know. I mean, certainly he would have to come forward with evidence.
If it were established that he just sat by silently while Mr. Santa Marina waived defenses and, did whatever he did, would that be sufficient to support a finding subsequent that representation, that Santa Marina had Koukis's authorization to represent him?
If there were affirmative evidence in the record, which there is here, that he did in fact know, then the preponderance of the evidence on the motion record and at the hearing would demonstrate that he was awareness. It's his burden to come forward and demonstrate what he knew.
If
That
you
he
know
was
someone,
aware of what? That
Yeah.
he was aware of what
What are you aware of?
specifically?
To demonstrate when he became aware of the action, Your Honor. The evidence that's in the limited record to date is that Koukis was aware of the action by at least 2018, and that is consistent.
Does he have to be aware of the action or the representation?
Both, Your Honor. And the reason why we know that is because in the email exchanges.
Oh, I'm sorry, I was asking a legal question, not a factual one. That is, if he knew the action was proceeding but didn't know that the lawyer was purporting to represent him, would that be enough to bind him?
That would not be enough to bind him to the
So he needs to know
representation.
that the lawyer is representing him.
Correct, Your Honor. And what we know, there's an additional issue here, which is that a hearing isn't even necessary in this case because it is undisputed that Koukis was aware of the judgment against him and that the representation that had been done on his behalf, he was aware of that no later than July of 2019. And he indisputably dragged his heels and did not move to vacate the judgment against him on the behalf of unauthorized appearance of counsel for a period of nearly 2 years. During that time, Gibson Dunn engaged in judgment collection efforts against him. We've had the loss of evidence. It's not clear what evidence exists as to what Koukis knew when he knew it, what the circumstances of his relationship were. And as this court is aware, Mr. Koukis has unfortunately passed away. So because of his own willful delay for a period of 2 years, we now have a loss of evidence that certainly prejudices Gibson Dunn at this point, just trying to make good on its rights to this judgment and engage in judgment collection efforts in the ordinary course. So the court doesn't even need to get into whether or not a hearing is required because the court should hold that Koukis is equitably estopped as a matter of law on the basis of his undisputed willful delay in making his motion. But at the very least, the appellate division erred in holding that he had satisfied his burden of demonstrating as a matter of law that there was an unauthorized appearance of counsel here. Beyond that, Your Honor, the only thing I wanted to get to this court to reemphasize is just that there has been a lack of discovery, a lack of fact-finding, a lack of anything, and all we're asking for is for the court to to make sure that we can proceed in the ordinary course and pursue our rights. With that, unless there are any further questions, Your Honor, I'll reserve the rest of my time for rebuttal. Thank you.
Thank you. And I neglected to mention that we are being joined by our colleague from the Third Department, the Honorable Lisa Fisher.
And may it please the court, Joseph Aronauer, attorney for the estate of George Koukis. To my right is co-counsel Henry Korn. I would like to start off with dealing with the estoppel argument. As we put in our brief, for estoppel to apply, Gibson Dunn would have had to change its position, and it would have had to have been prejudiced. The motion court made a factual finding that Gibson Dunn was not prejudiced, and that was not changed by the appellate division. So it has been established for purposes of this appeal that Gibson Dunn did not have prejudice. And they did not change their position because their position has always been that they're going to go forward and forward and forward and forward. I think when you look at this case, if you look at it in terms of a hurdle race,
Well, what, other than an affidavit saying, I didn't approve that representation, I never authorized him to represent me, what else was put in?
what else could he have done?
No, what else was actually submitted to support the
Oh,
claim
oh,
that this was an
oh,
unauthorized
Your
representation?
Honor, I'm very glad you asked that question.
Me too.
What was submitted was details on the denial. You never billed me. I never communicated with you. The only communication I had
Besides
with you.
his own words,
What's that?
just his own words, that's what you're outlining now?
Well, yes, and he annexed as an exhibit an email, the only communication he had, where he told Santa Marina not to represent him. But there's more.
So if the other side had something that suggests the opposite, should there not have been a hearing or discovery?
Well, Your Honor, when all these things were filed, and I just want to flesh out the response to Judge Rivera's question. In addition to that, we annexed the sworn statement of Santa Maria, where he admitted that he did not have the contact information for Koukis. And so I think it's the burden of proof, after you make a denial and you back it up, and also before the motion court.
So that as a matter of law establishes that he had no authority to act?
I think the answer is because there were electronic filings in this case, and Santa Marina was an attorney of record, and he got those filings, and he never responded. He never denied it. What are we having a hearing about? And the appellate division properly held.
With respect to agency, you don't think?
Well, agency, there's clearly not actual agency.
What about
There's-
implied?
Why?
What about implied?
Okay, a parent authority has to work with a principal, in this case, Koukis, by words or conduct, tells Santa Marina that Joseph Deanna is my agent. But because there was no communication from Koukis to Santa Marina, you never get to a parent authority. There is no apparent authority.
But isn't that what we don't know that they're looking to develop in the record? We don't have that
Well,
information?
Your Honor, we do have the record because we submitted statements, Santa Marina got it. The only people who know what happened between Santa Marina and Koukis are obviously Koukis and Santa Marina. Fair enough. So Koukis submits details, I never got a bill, I never had communication other than telling him not to represent me.
That was after the fact, though, because it seems like
Yes,
this
so-
whole thing stems from the litigation in California with Google, and your client was aware of that, right? And he was,
That I don't know, and it's not relevant.
well, it is relevant because a judgment is entered based out of California, and that judgment is then perfected or taken up here in New York.
I think the key point is Santa Marina got notice of the allegations as to the relationship between him and Koukis. He did not respond. He was an attorney of record.
When did he get that notice?
Instantaneously, that's the way electronic filings work. When Koukis made his motion, there was an electronic filing. Every attorney of record gets notice instantaneously, or I would say electronically. And Santa Marina was an attorney of record. He got notice of this. He knew everything. Santa Marina is also the person.
I'm sorry, and then you're saying he continued to represent Koukis?
Well,
I'm
he-
confused,
he
I'm having
purport-
difficulty
He
following your
purported
argument.
to continue to represent him. And one of the things in this case is if you use a track analogy of a hurdle race, there are two hurdles here. Hurdle one is there must be an establishment that Santa Marina was authorized to appear. If you get over that hurdle, the second hurdle was Santa Marina authorized to waive a dispositive defense, the lack of personal jurisdiction.
Why does he specifically have to be authorized to do that if you've gotten over the first hurdle?
Because, Your Honor, the decision from Judge Kagan Halleck said an attorney's authority to conduct litigation is hardly unbounded. And what we cited in our brief is two appellate division decisions, one from your department, Gordon versus Aspasis, where the court said that when it's a substantial right, the attorney has to get authority from the client. And in that case, the Gordon case, it was a question of giving up rent. And they said the attorney did not have authority to give up that substantial right. In the Bryan case, which we also cited, it was also held the attorney did not have a right to give up a substantial right. In this case, in that case, the right to have a cap on an insurance company's fees. So there is nothing in the record to indicate that any of the defendants knew that Santa Marina was giving up a dispositive defense. And again, when you look at the stipulation, waiving the personal jurisdiction, it distinguishes between service of process, which routinely is given up, and personal jurisdiction. Koukis was a European domicile. He lived in Switzerland. There is no lawyer in this courtroom who would give up that right. Certainly, no one in this courtroom, no lawyer in this courtroom would give up that right without speaking to their client. And if you read Koukis's affidavit, he distinguishes.
Why can you decide that without the hearing? I mean, he's saying all they want is a hearing.
Well,
Maybe you can establish that. Maybe you're right.
well, we are obviously at a tremendous disadvantage because of Mr. Koukis's death. But I
Well, it works
think
both ways, I
in order
understand.
to have a hearing,
Yeah.
you have to show you got something. You have to show there's something here to require a hearing. And both the motion court and the majority of the appellate division factually found there was no basis to say that Santa Marina was authorized to either appear or to waive the dispositive defense of personal jurisdiction. That is not merely a substantial right, but a dispositive right, because even in the dissent,
So then what should Santa Maria have done? Are you saying he should have then communicated individually with everyone he was representing regarding that waiver?
exactly, because every individual
And what
defendant
else- what
had
else-
rights.
What else in the representation did he then need to also get yet another indication that he could make whatever choice he wanted to as a litigation strategy?
Well, I think the way Judge Kaye said that the rights of an attorney to conduct litigation is hardly unbounded. And what the appellate division decisions have said, have drawn the distinction when it's a substantial right. What we have in this case is more than a substantial right. It's a right that is dispositive.
Well, that
Every
assumes,
single-
excuse me a second.
What's that?
That assumes that there isn't personal jurisdiction over him in some other way.
Well, Your Honor,
I understand
even
his
the dissent in the
dissent.
appellate division, when you read footnote 1,
You know.
it concedes that but for the waiver,
And does that bind us?
nothing in the appellate division binds you, Your Honor. I acknowledge that, other than the scope of review, that
Right,
if
and the
the motion
plaintiff
court...
here does have another argument about why you can essentially disregard corporate formalities and find personal jurisdiction over Mr. Koukis.
Oh, you're talking about the fraudulent conveyance claim. And the fraudulent conveyance claim fails to impose personal jurisdiction on Koukis. One, for the reason asserted by the appellate division, it doesn't state a cause of action. And the other reason, which was really my primary argument at the appellate division level, was That claim has no connection to Koukis's 4 visits to his daughter in New York City. That is the totality of his connection to the state of New York. And so we are talking about the world of specific jurisdiction. And it is due process, both federally and in state, that there has to be a connection between the complaint of acts and the defendant's actions in the state of New York.
I don't recall, but can you clarify, was there any connection in terms of the transactions? I know he initially invested $1 million through Zeus, and then there was a subsequent loan and another subsequent bailout, like about 1.9 million, I think. Was that conducted through the state of New York, or was that done out in California?
The motion court, and we have a list of all the factual findings that were not disturbed by the appellate division, says he did not meet in New York. The meetings were in London, they were in Hong Kong. So if I remember my pages of the brief correctly, we list the jurisdictional findings on pages 16 to 18. And the motion court wrote a 24-page decision. It was a very careful, well-thought-out decision. It made numerous factual findings, none of which were changed by the appellate division. And as I understand the rules of this court, if there are factual findings made by the motion court and they're not changed by the appellate division, they are binding. Gibson Dunn does not get a second round at appellate factual finding
Can
at
I
this
get
court.
back to the point of his request for a hearing, which is what I understood him to say, and your statement that you're at a disadvantage, and of course, that's because Mr. Koukis is deceased. I assume this is what you were referring
Right.
to. Does this mean that you are unable to take a position in the hearing, that you are going to be unable, if a hearing was granted, to proceed?
Having tried quite a few cases, Your Honor,
Yes.
it's always good to have a client there. Okay, and I think we could do what we have to do without Mr. Koukis, but it's always helpful to have a client. And one of the things...
Well, you have a client, but I get your point. You mean
Well,
Mr. Koukis?
it's an estate now.
Yes, yes.
And so one of the things is that on a motion to vacate a default judgment, like we have before this court, the burden of proof to establish personal jurisdiction is on the plaintiff. And Koukis's papers truly establish, with sworn statements from Santa Maria in response to the information subpoena, there was nothing there. There was no basis. The only possible basis, and we deal with this in our brief, is to say there was ratification of Santa Marina's both appearance and waiver of the personal jurisdiction, or there was estoppel. Estoppel we've discussed. Gibson Dunn didn't change its position, and there's a binding factual finding they were not prejudiced. As I understand ratification, they have to show that Koukis adopted Santa Marina's appearance and his waiver of personal jurisdiction. It is counterintuitive for any European domicile to adopt a waiver of personal jurisdiction in a case in the state of New York. It doesn't make sense. And that is why the majority of the appellate division, consistent with the motion court, found there was no basis to say that Santa Marina was both authorized to appear and to waive the personal jurisdiction defense. And unless the panel has any questions, I will let my adversary have his rebuttal time.
Thank you.
Counsel, could you pick up where he just left off with respect to why would his client waive that jurisdiction being a European domicile?
Your Honor, I'm not counsel for Mr. Koukis, and I can't speak to the strategic considerations that they may or may not have made. What I know is the limited record that we have on the motion here, which is that he did. It wasn't just a stipulation that he expressly waived it. He also filed an answer and litigated on the merits for 2 years. Those are strategic decisions that are made all the time as a matter of litigation.
But doesn't that also go back to your argument that a hearing is required with respect to what did or did not happen, discovery, and as opposed to what the court did below with it just vacating?
That's right. I mean, that's exactly right. Now, I would like to start with the first point I was going to make, which is that, that would contemplate, further proceedings in this action, but the courts don't need to get there. And the reason why is because Koukis is stopped from making these arguments because Gibson Dunn has been prejudiced as a matter of law. As this court noted in the Halleck case, halting the machinery of litigation is itself prejudicial. As a matter of, it does not matter whether or not there is a loss of evidence. It doesn't matter, which there is here. It doesn't matter whether or not Gibson Dunn engaged in years of litigation to, collect on a judgment and went through the expense and the time of that, which it did. But that is prejudicial per se, and now we have the untimely passing of Mr. Koukis himself, which has altered the complexion of any factual hearing that would happen, and that was due to the undisputed dragging of his heels for 2 years before he moved to vacate. He could have done this within days or weeks of getting the judgment and learning about the authorized appearance, even if you credit all of his claims that he was unaware of the litigation throughout the entire course of the litigation. He sat there from July 2019 all the way through the rest of 2019. He's emailing with Santa Marina. He then sits on it for all of 2020 and then into the spring of 2021. It was only after Gibson Dunn moved and got an order turning over his property and had moved for civil contempt because he was not complying with that he then moved and to vacate the judgment on the basis of unauthorized appearance of counsel based solely on a few sentences that he lobbed in an affidavit. He doesn't explain anything about what he knew, when he knew it, why is it that his co-defendant and his counsel litigated on his behalf for years. There's absolutely no factual detail about that whatsoever, and now the record has changed, unfortunately.
But I don't know why it's really fair for Gibson Dunn to believe post-mid-2019 that Santa Marina had the authority to act as Koukis's lawyer, right? We knew that Santa Marina moved to withdraw. He said Joseph Deanna was the only defendant he'd been in contact with. He had no contact information for Koukis at all. Supreme Court noted in the engagement letter that it was unclear who he was representing. So at least from that point on, Gibson Dunn should have been alerted or couldn't have relied on anything that Koukis was doing to demonstrate that Santa Marina represented him.
Your Honor, we have a judge, even after Supreme Court issued that decision, denying Santa Marina's attempt to vacate his representation of all of the defendants, the court then went on to enter a default judgment. All Gibson Dunn had at that time was a judgment that was entered in the ordinary course, and Gibson Dunn went to collect on that judgment. That's all it did. There was no further evidence that Santa Marina lacked any authority to represent Koukis for the entire time that Koukis was evading that judgment. All of the email correspondence that is in the record, Gibson Dunn was not aware of that correspondence for much of the time that Koukis was preparing his motion to vacate. And all of this could have been avoided if Koukis had simply moved promptly and to vindicate the rights that he claimed that he had. And with that, Your Honor, I just wanted to say one other thing, which is that the importance of this appeal, think about what this means for litigation here. What we had here was we had an officer of the court who appeared on behalf of a defendant for a period of years and litigated for all of the defendants consistent with all of the evidence that we have here in the record. And Gibson Dunn was told both personally by that counsel and in public filings for a period of years that he had authority to represent Mr. Koukis. Now, even after Mr. Koukis has passed away, we have received, we've received word that even my friend sitting here has authority to represent his estate, and we've accepted that representation, just as a court would during the litigation in this case, accepted the representation by Santa Marina that he had authority to represent Mr. Koukis, because absent any evidence to the contrary, litigation in the ordinary course in New York has to ascribe at least some weight to the statements by counsel that they have authority to act on behalf of their clients, that there's a presumption of regularity that goes there. And what the appellate division decision did in this case was it ascribed literally 0 weight to the public filings and sworn statements of Mr. Santamarina for a period of 2 years. And that's an error as a matter of law. This court has jurisdiction to review it, and it should review it, and it should reverse.
Thank you.
Thank you.